Hi, welcome to Jus Cogens, the International Law Podcast. This is the second and final part of a two-part series on treaty interpretation and the updated commentaries on the Geneva Conventions. To listen to the first part of this series, you may visit our YouTube channel or go to Anchor FM to listen to the audio version. Moving on, I'd like to engage Professor Murphy on some of the other elements of treaty interpretation, namely subsequent practice and other relevant rules of international law. So starting first with subsequent practice. Professor Murphy, I'd like to know your thoughts on what amounts to subsequent practice establishing agreement of the parties regarding interpretation. And is it enough that states don't object to a particular interpretation? How does it work?
So first, let me note that we're talking about the existence in Article 31 of several different means of interpretation. Article 31, paragraph 1, we've already addressed the idea of looking at the ordinary meaning, looking at the object and purpose of the treaty, looking at the context of the provision that you're interpreting, which can include other provisions of the treaty, preamble, annex, and so on. And now we're talking about Article 31, paragraph 3, specifically subparagraphs A and B, which talk about subsequent agreement of the parties to the treaty in interpreting the treaty and subsequent practice of the parties to the treaty that constitute an interpretation of the treaty. I just note that these are all different means of interpretation in Article 31 that, as presented in Article 31, are not in any particular hierarchical relationship with each other. So I think Liesbeth is right that you start with the ordinary meaning of the provision that you're interpreting. That's the most obvious place to start. But actually, these different means of interpretation all come into play as part of a combined operation in order to reach an authentic interpretation of the treaty. That is, what did the parties actually intend or mean when they adopted the provision at hand? The International Law Commission, when it was drafting the articles that became the Vienna Convention on the Law of Treaties, talked about it as being a crucible in which you throw all these different means in order to then produce out of the crucible the correct interpretation. So with that in mind, yes, one moves on to Article 31, paragraph 3. And in subparagraph A, you have this ability of the parties to the treaty to reach, subsequent to their adoption and ratification of the treaty, reach some kind of agreement about how to interpret the treaty. That could be done in writing. It could be done in treaty form. It could be done in a form that's not a treaty, that's not even in writing. There's no specific form by which this Article 31.3a subsequent agreement might occur. But if you did, by some happenstance, have the 193 parties to the 1949 Geneva Conventions adopt, let's say, a declaration that said Article 52 of the Third Geneva Convention on Prisoners of War should be interpreted as meaning X, then that would be one of the many means of interpretation that one would apply in Article 31. In Article 31.3b, you have this issue of subsequent practice of the parties in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. I think what we're talking about now is conduct of the parties, probably happening in a non-harmonized way. It's just all 193 parties to the 1949 Geneva Conventions are acting in a particular way that suggests Article 50 should be interpreted to mean X. when that happens, probably you have some number of states engaging in what I would call active practice. That is, they actually have prisoners of war and they are interpreting Article 50 as meaning X. And then you're going to have maybe even more states parties that are not actively engaging in conduct, but they are reacting. And that reaction might be saying, we agree, this is interpreted properly, or it could be silence. And if it's silence in the face of an expectation that normally a state would react to the active conduct, then if you put all that together, you may well get an agreement of all of the parties to the relevant treaty based on their individual practice. So both Article 31.3a and 31.3b ultimately lead you to a place where you say there has been an agreement among all the parties to the treaty as to the way to interpret a particular provision, but they get there by slightly different means. The first one is a agreement as such, and the second one is practice in the application of the treaty that demonstrates the existence of an agreement. I think you also were asking me if you don't have an agreement of all the parties to the treaty, does it fit? And the answer is it does not fit for Article 31. You do need, for an Article 31 analysis in paragraph 3A or B, an agreement of all the parties. But if you have something less than that, let's say an agreement of half the parties or a third of the parties, it is the case, at least according to the International Law Commission, that falls under Article 32, supplementary means of interpretation. It's relevant evidence in engaging in an interpretive process, but it has a different status falling down under Article 32 of the Vienna Convention on the Law of Treaties, and we'll talk a bit about how Article 32 operates in due course. But that's basically how I would view the subsequent agreement and subsequent practice concept in the VCLT Article 31.
Right. So moving beyond subsequent practice and subsequent agreement, how do you see the relevant rules of international law which are applicable in relations between parties for the purposes of multilateral treaties like the Geneva Conventions? Do you think that other treaties can be used for this purpose?
So in Article 31, paragraph 3C, it says that you can take into account any relevant rules of international law applicable in the relations between the parties. So again, putting this in context, we've got a particular treaty in front of us. We're trying to interpret a particular provision or provisions within that treaty. It is fair game under Article 31, paragraph 3C, to take into account relevant rules of international law applicable in the relations between the parties to the treaty that's in front of you, right? And I do want to stress that idea of applicable in the relations between the parties. You're looking for other rules that are out there that apply to these particular parties in front of you, which could be 2, it could be 10, it could be 193, but these relevant rules have to be in place already vis-a-vis the parties to the treaty that you're interpreting. The other thing I would emphasize, and this of course is true of all the means of interpretation that we're talking about, it's for purposes of interpretation, right? It's not for purposes of modifying the treaty. It's not for purposes of amending the treaty. It's for purposes of interpreting the particular provisions before you. And I stress that just because the idea isn't that you are going to import into this treaty all sorts of rights and obligations that exist somewhere else. in the relations between these parties. You're only looking at the provision of the treaty that's in front of you. You're using these relevant rules that are coming from elsewhere to interpret that particular provision and not to import lots of other things. Now, having said that, the value of this possibility of interpreting the treaty in front of you based on these other rules that are applicable between the parties is that it does allow us to engage in some amount of harmonization of international law. It's often talked about how international law is fragmented with different subject matter areas, and that we need to find a way of engaging in what is sometimes called systemic integration, where we attempt to bring different areas of international law together so that it works as a whole, and that we don't have this, disparate rules and obligations that are operating, in different spheres in different ways. So one value of this reference to relevant rules of international law is to try to make some sense out of international law. You asked, is it okay when interpreting something like the 1949 Geneva Conventions to look at other treaties between the parties that could shed light on the meaning of a provision within the 49 Geneva Conventions? My answer is yes, in principle, but I think there are some difficulties. So one difficulty is if you're interpreting a treaty like the 1949 Geneva Conventions that has 193 states parties, then the most obvious way you might be using another treaty is when it's a treaty that is binding upon all 193 parties. Right, so like the UN Charter, if there's something in the Charter that shed light on the meaning of a provision in the 49 Geneva Conventions, which were concluded 4 years after the Charter, that seems plausible to me. What's less obvious is if you're looking over here to, let's say, a treaty between Ethiopia and Eritrea, for purposes of interpreting the 1949 Geneva Conventions, now you're using a treaty that only binds 2 states, and you're using it to interpret a treaty that is among 193 states. That might seem appropriate in the context of a dispute between Ethiopia and Eritrea, but even then, the question would be, well, is that really what the 49 Geneva Convention means, based on just this limited, bilateral treaty over here? So I think there are some interesting issues there that one would need to grapple with, but certainly it is possible to use other rules of international law for the purpose indicated in Article 31(3)(c).
Right. No, that's very interesting. Dr. Henckaerts, I'd like you to weigh in on the same issue in terms of what role do these relevant rules of international law play in terms of interpreting almost universal treaties like the Geneva Conventions and their additional protocols?
Yes, thank you. Yeah, the challenge there, of course, is that we have to look at subsequent practice, and by now there is a lot of subsequent practice. And so to the extent that it does not meet the high threshold of Article 31 that Professor Murphy just explained, we can still rely on it as a supplementary means of interpretation under Article 32. Now, for other relevant rules of international law, there are similarly huge developments since 1949. And so to make sure that the whole international law system is operating in an integrated manner, as he mentioned, one has to take into account of the various obligations of the parties. So, and most of these developments that are relevant are in the area of multilateral treaties. So not so much bilateral treaties, but mostly multilateral treaties in the area of human rights law, in the area of refugee law, or could be in the area of, not even codified rules of international law, such as the Articles on State Responsibility, which have clarified a number of things which are already hinted at or pointed at in the Geneva Conventions, but of course the Geneva Conventions could not integrate the draft articles on state responsibility because those weren't drafted yet. So our approach has been to set out these other relevant rules of international law, but to indicate in the introduction that, of course, when we refer to these additional rules, that they are only going to be relevant and binding for states parties to those treaties, except to the extent that they are customary. And this is also relevant because there have been other rules of international humanitarian law adopted, other treaties, in particular the additional protocols of 1977, for example. So they add a whole set of rules to the Geneva Conventions, but as we know, the additional protocols are not universally ratified like the Geneva Conventions. So for states that are not party to the additional protocols, they only have to consider those rules to the extent that they consider them or that they constitute customary international law. But for many states, about more than 170, of course, the additional protocols are binding treaty law. And so for them, they have to read the Geneva Conventions together with the additional protocols. So it seems to us that if we give a commentary on a particular provision, we at least have to point out what it means that there's also a relevant provision in the additional protocols. And we take the same approach with other treaties, but setting out as we do that, of course, the treaties that are referred to are only relevant and going to be binding for states party to them.
Right. Coming back to you, Professor Murphy, Dr. Jean-Marie Henckaerts spoke about supplementary means of interpretation under Article 32 of the VCLT. How do you see the role of preparatory documents, in this system of supplementary means of interpretation?
So I'll start by noting that Article 31, sets forth the general rule of interpretation. If you look at the heading of that particular article, and sets forth a series of means of interpretation that we've been talking about and that can be used as a part of this interpretive process. Now we're shifting to Article 32 of the VCLT, which is entitled Supplementary Means of Interpretation. And it's a very interesting article because here we do seem to have some sense of hierarchy operating among these means of interpretation, with the Article 31 means being the primary or the general means, and then the Article 32 means of interpretation being in some sense supplementary. The language says you can have recourse to these supplementary means of interpretation in order to confirm the meaning of Article 31 or to determine the meaning where an Article 31 analysis leaves things ambiguous, obscure, or leads to a result that's absurd or unreasonable. So just looking at the text of Articles 31, 32, it seems to be you're not supposed to go to Article 32 unless there was some problem with your Article 31 analysis, or you're just trying to confirm it, then you go to this. So there is a hierarchy within the VCLT. Having said that, my own experience in reading lots of international court cases and whatnot is that this hierarchy is not followed rigorously by international courts, international tribunals, governments, scholars. It is there, and it's there for a reason, I think. I do feel that when governments were adopting the VCLT, they did believe that relying on something like negotiating history of a treaty was risky because it's often unclear. It often involves different voices saying different things. And the governments at the table at the time the treaty is adopted are not often the same governments at the table 20 years later, 40 years later. So many governments that are going to be bound by this treaty were not at the negotiations, and yet you're using those negotiations in order to interpret the obligation to which they're bound. So I think there is a reason for this hierarchy, and it's worth knowing about that and thinking about it. But when you actually look at the way courts decide cases, including the International Court of Justice, there often seems to be a grabbing of the ordinary meaning, a little bit of object and purpose, and a little bit of negotiating history, and this, that, and the other in order to come up with the interpretation. So it's worth focusing not just on text, but on practice when we think about this. The last thing I'll say about it is your question was about negotiating history, preparatory works. Sometimes we use the word travaux préparatoires from the French. I would note that Article 32 refers to supplementary means of interpretation, including the preparatory work. So although sometimes we equate Article 32 with negotiating history, in fact, it's broader than that. And indeed, we've already talked about how subsequent practice of some parties to a treaty that shows their interpretation, but not all parties' interpretation, could fall under Article 32 as a supplementary means of interpretation. So it's broader than just travaux préparatoires, but obviously the travaux préparatoires are a part of Article 32.
No, that makes a lot of sense. Now, if we contextualize this discussion more towards the updated commentaries to the Geneva Conventions and the methodology used behind them, Dr. Henckaerts, I'd like to start with you and just ask you a broader question about, is the interpretation of a law of war treaty, or let's say an IHL treaty, different than the interpretation of any other type of treaty, or should it be?
Well, I would say that in general, it shouldn't be different, because the law of war is part of international law. And so law of war treaties are subject to the same rules of treaty interpretation as any other treaties. Now, I know some people may think that the extreme circumstances for which law of war treaties were drafted, namely armed conflict, would maybe justify different methods of interpretation. But the circumstances of armed conflict is already taken into account in the terms of the treaties. And I think that the rules of treaty interpretation are adapted to deal with different areas of international law. We've already talked about the ordinary meaning and the object and purpose. So these elements typically will be specific to the content of each treaty in question. The object and purpose is specific. For example, for the law of war treaties, typically they will reflect the balance between the requirements of humanity and military necessity. So that's why, in light of what Professor Lijnzaad has said, we identified the object and purpose of the third Geneva Convention, that prisoners of war have to be treated humanely, while allowing belligerents to intern captured enemy combatants to prevent them from returning to the battlefield. So we use that framework for this specific treaty for interpretation. In addition, the other elements like subsequent practice and other relevant rules will also differ according to each treaty. So nevertheless, collecting subsequent practice, as we've just heard, may be a particular challenge in the area of law of war, where practice may be covert or remain undisclosed for security reasons. So obviously only publicly available practice can be taken into account. We can't use or cite what is secret or not known. So for our work, we have done a lot of effort to collect such practice. And we have also benefited in this regard, I would say, from our field experience that we can draw upon, because we've been a key witness to how POWs have been treated and have carried out numerous visits to POW camps in the past 7 decades, pursuant to the role that the convention has assigned to us in this regard. So there may be specific considerations and challenges, such as collecting practice in the area of law of war treaties, but overall, I believe it's the same framework that applies, the framework of the Vienna Convention on Law of Treaties.
Right. Professor Lijnzaad, I'd like you to chip in on the same question. Do you think there's a difference between the interpretation of a law of war treaty compared to any other type of treaty, or is it the same?
I very much agree with what Jean-Marie has said. And I think there is another reason why it is so important to follow the applicable general rules of the law of treaties when interpreting law of war conventions, Geneva Conventions, because this also goes to credibility and accountability for the legal thinking of the ICRC. It is, I think, important from the perspective of the question very much at the beginning of our discussion, who interprets the law? Well, the ICRC is clearly not a state, but is very much an organization that is directly concerned with the interpretation of the rules of the laws of war, of the humanitarian law treaties. And I think that by going meticulously through the rules and also providing a quite detailed explanation at the beginning of all these revised commentaries so far, that in itself, I think, may take away a lot of criticism of the revised commentaries and the content of those commentaries. So by using a very precise and analytical manner, that is, I think, in an area where I guess there is always this ongoing tension between the humanitarian needs and at the same time what is necessary from the perspective of the notion of military necessity. It is crucial to be able to demonstrate that your reading, your contemporary reading of, shall we say, aging conventions, 1949 is a while ago, it is essential that your contemporary reading of those conventions is based on a solid underpinning in the law of treaties. And I think that is also why I think this is such an impressive project in terms of the team in Geneva going after all sorts of possibly relevant practice that might demonstrate that in certain respects the interpretation of the conventions has changed or is in the process of changing. It clarifies that it is not just something on the wish list of the ICRC, but it has a solid basis in the law of treaties. I think that's important.
Right. No, thank you for that insight. And it certainly is a very impressive project undertaken, and headed by none other than Dr. Henckaerts. So kudos on that. Coming back to you, Dr. Henckaerts, do you think the practice of certain states within this context, gets more weight than other states? What about, states who are frequently involved in armed conflicts? How do they fit in all of this?
Well, I would say that all states have an equal interest in the development and interpretation of IHL. So all practice has to be taken into account, including that of states that are not involved in armed conflict. It's true that some states have more practice, or their practice is more easily accessible because it is public. And we just mentioned that we can only rely on public practice. For example, when they publish their military manuals on the internet, which is very useful. But that does not mean, in our opinion, that the practice and views of states with less practice or who are not involved in armed conflict should be disregarded or should not be given proper weight in the interpretive exercise.
Right. So coming back to you again, I want to ask you the million-dollar question. What is the role of commentaries and what is the importance of commentaries in the interpretations of treaties in general and specifically within this context?
Yes, we've already hinted at it, but maybe I'll repeat some of the things we said. So Commentaries bring together all the available elements for the interpretation of a specific treaty, usually on an article by article basis. So all the elements that we've already mentioned. So they look at the ordinary meaning of the terms, the context, the object and purpose. They report subsequent practice and other relevant rules of international law. Then they look at supplementary means of interpretation under Article 32, as Professor Murphy said, either to confirm the meaning or to establish the meaning when the general rule of interpretation has left it ambiguous or obscure. So I think it's important also I would like to add here on subsidiary means of interpretation, indeed, that they include the preparatory work of the convention. This is the wording of Article 32, but also the circumstances of its conclusion, but also subsequent practice that does not meet the standard of Article 31. We have talked about that. As well as, I would say, judicial decisions and scholarly writings, because both of these are recognized as subsidiary means to determine rules of international law under Article 38 of the Statute of the International Court of Justice. So if they can be used to determine the rules of international law, then surely they can be used to interpret the rules of international law. And since Article 32 leaves the list of the use of the word including, and also because if you look at commentaries and at court decisions and so on, you see they often rely on judicial decisions and to some extent also on scholarly writings. So these elements, all of these, are brought together in a systematic manner, in a summarized manner in a commentary. So I would say it serves as a reference tool for practitioners and academics to insist in their work. We've already said commentaries are not law, they don't change the law, but they serve as a reference to establish the meaning of specific provisions for those who have to interpret and apply the law. So the same applies to the ICRC commentaries. They bring together these elements that inform treaty interpretation for use by practitioners, and there are quite a few in this field: government lawyers, military legal advisors, I mentioned, judges, international organizations, also diplomats, I would say, who work on resolutions, but also academics and others. Basically, anyone who has to apply and interpret the Geneva Conventions as part of their work. And so that will be the same for commentaries in other fields, because these are not the only commentaries. The field of international law has seen the emergence of many commentaries, which in my opinion also shows their role and their usefulness in this field.
Right. Before I prod you further, specifically on the new ICRC commentaries, I want to get your take, Dr. Murphy, about the impact and utility and role of commentaries in general. How do you see this fundamental question?
So there may be a shade of difference between my view and that of Jean-Marie in that I do not view commentaries like that of the ICRC as themselves being a supplementary means of interpretation. And I'm not sure that's what he said, but I think for all of these means of interpretation, we are focused on the parties to the treaty. What was their meaning when they adopted the treaty? And so when we're looking at supplementary means, that can include the negotiating history where those parties are talking to each other leading up to the treaty. It can include their subsequent practice that's not of all the parties, things of that sort. So I don't view commentaries produced, whether it's the ICRC or the International Law Commission, as strictly speaking being a supplementary means. But if instead the proposition is those commentaries gather up information about state practice, about negotiating history, about relevant rules of international law operating between states, and pull them together and present them to us, and thereby gives us a window onto these other components that fall under Article 32, I accept that entirely. And I just would draw that perhaps shade of a distinction, at least for me. Having done that, I'll just note that when I was in the government and doing political military matters, including during the US intervention in Panama and the first Gulf War and so on, you know, the first thing I pulled off the shelf would typically be the 1949 Geneva Conventions. And the second thing I would pull off the shelf was the Pictet Commentary. We didn't have the new commentaries at the time, would have loved to have had them, but the reality is, I think any government official, lawyer working on law of war issues is going to pay extremely close attention to these commentaries because they have a wealth of information within them. And governments will sometimes disagree with the ICRC that the emphasis on this or that was not appropriate and you didn't take account of this and that. Of course, that's going to be true, but it's an extraordinary service that the ICRC is providing in this regard. And these commentaries are a remarkable achievement that I think will have a significant effect. And I'll just finish by saying, you know, states react to the commentaries, and that generates its own practice that is also pertinent when you're doing an interpretation of any law of war treaty. So there's a bit of a symbiotic relationship here where the ICRC is ascertaining state practice, but it's also generating state practice because of the work that it does in the commentaries.
Right. Professor Lijnzaad, if I can have your reflection as well on the same question, how do you see this, question of where do commentaries fit in the larger scheme of things when it comes to interpretation?
Well, a point I wanted to make is that a commentary is not a protected title. I think we must distinguish between the Pictet commentaries and now the revised commentaries as being established under the umbrella of the ICRC, and the fact that, and I agree with that, many more commentaries have appeared on a large variety of issues. What I think is quite crucial to the commentaries prepared by the ICRC is the methodical approach and the thoroughness. I'm not sure that that is necessarily the case for anything else that's called a commentary. You see commentaries that are essentially a collection of essays about crucial provisions in a particular treaty. That is not the same. So I think that the standing that the ICRC commentaries have is also very much due to the methodical approach and to the critical reflection on all types of relevant material that may be available with respect to various provisions in the conventions. So I would say that some commentaries are very often a sort of easy shortcut, an easy introduction to provisions that all of a sudden you have to say something about. And I very much recognize what Sean was just saying. It was the same for me when I was still working in government. Something had happened somewhere. Of course, you don't know all the provisions in all the Geneva Conventions by heart, so you had a sense of where the provision was. And then for quick reference, I'm going to see what Pictet and his colleagues wrote about it. Now, increasingly, you would end up thinking, yeah, but that's not really what I'm looking for. My question is somewhere in the domain of that provision, and through my regular interpretative practice, I just still do not find a sense of where I should be going. So in that sense, that was also about the fact that the revised commentaries, I think, were much needed at this point in time. I know a number of good commentaries as commentaries in the sense and similar to to the ICRC commentaries on the Geneva Conventions, and those publications stand out because they are thorough and meticulous and will really give you a good entry into problems surrounding particular provisions. But that's not the case for all commentaries. The other commentaries, in the sense of a collection of essays, very interesting, very relevant, but maybe not always the right title.
Right. So it's good to have everybody's thoughts on that important point. Coming back to you, Dr. Henckaerts, what is specific and new about these updated commentaries by the ICRC? How do you see them?
Well, what is specific about the new commentaries is that they are an update of existing commentaries, the famous ICRC commentaries. So an update that is based on information that has emerged in the decades since the original commentaries were published. And this relates to the issues we've been talking about, to the emergence of subsequent practice, to the adoption of other relevant rules of international law. But so that means that we have to take a different perspective now from the initial commentaries, which were published in the 1950s. So if you place yourself for a moment in the perspective of the 1950s, you look at the conventions as they were just adopted, in light of the preparatory work mainly, because that was just finished. The conventions were not yet widely ratified. And you also looked at previous armed conflicts, which at that time were mainly the Second World War and, for example, the Greek and Spanish civil wars. So, you're in the 1950s. But today we're in the 21st century. So the old commentaries indeed were seriously outdated because so much time had passed. 7 decades, actually, during which new practice and other relevant rules of international law emerged. So then if you take today's perspective and you look at how the conventions have been applied and interpreted, then of course the preparatory work and the Second World War are quite remote in time, and there's much more recent practice and other relevant rules. And that is exactly what the Vienna Convention requires us to do. What is also unique, and I've already mentioned this about these commentaries, and in particular the one on the Third Geneva Convention, is that it's informed by our own experience. Because as you may know, the Third Geneva Convention in Article 126 mandates the ICRC to carry out visits to POW camps. So that, I think, compared to other commentaries and even compared to our, compared to other commentaries, is quite unique feature of this own field experience. And furthermore, I would like to emphasize 2 points, is that we've not written this alone. We've involved a group of external contributors. So that's very different from the PK commentaries. So external contributors who bring their knowledge and insights to the project. And we have relied on a group of peer reviewers from around the world, practitioners, academics who have reviewed the drafts, done a reality check basically, and also made sure that what we write is clear and comprehensive. And this peer review has also allowed us to make sure that the commentaries, the new commentaries, reflect main diverging views. Professor Murphy already referred to the fact that there will, of course, be differences of views. But that is different from the original commentaries, which did not so much spend time on this, also because the conventions were just new then. So there was no time yet for these divergences to have appeared. So it's quite logical that these divergencies, some divergencies at least, have arisen now, given that so much time has passed since the adoption of the conventions. And so the new commentaries, in quite a transparent manner, I would say, reflect these divergent views.
Great, wonderful. So as my last question of the podcast, as an average, an amateur student of international law like myself, these updated commentaries might seem very long and very technical. So how useful are these for practitioners, in your opinion, Dr. Henckaerts?
Well, I think they're useful, and we've just heard it from 2 practitioners actually who said that their first reaction would be to pull off the conventions of the shelf, and second reaction to pull the commentary off the shelf. So So I believe that the length of the new commentaries or the old commentaries for that matter, or any other commentary, should not be an obstacle to their usefulness. The usefulness will be mainly inspired or based on how thoroughly and how systematic the research has been done, I would say, and how the methodology of the Vienna Convention has been followed. But the length should not be an obstacle to their usefulness, because they're not meant to be read like a book, right? They're rather to be used like an encyclopedia, so that you consult when you have a specific question. So the commentaries then will guide you to judicial decisions on a topic, or examples from previous conflicts, or best practices, relevant literature, and so on. And of course, also a range of practice, state practice that has been collected. I would also say that the length and level of technicality of a commentary is dependent on the convention in question, right? So the commentary on the third convention now that we just published and is coming out in print form in June, which has 143 articles, is more lengthy than the updated commentaries on the first and second Geneva Conventions, which have 64 and 63 articles respectively. I also want to say that this length and you know the growth in the length from Pictet to the updated commentary reflects exactly the extent of new developments in law and practice in the past 7 decades. So the commentaries have become longer, not because we try to make them longer, but simply because there's more information now that needs to be reflected. And that goes back to the very purpose of the update and to the methodology for treaty interpretation. So personally, I think the commentaries are very useful for practitioners, at least that's what I sincerely hope, since they bring together these various elements of interpretation in one place. Previously, up-to-date information about the conventions, you know, was spread out in numerous books, in archives, and in countless law review articles, right? Because the commentaries were from the 1950s. Several decades evolve. A lot is written about the conventions, but it's spread out in books and law review articles and different places. And so to find it, you need days or even weeks of research. Practitioners generally don't have time for this. And so to have all this information condensed in one place and up to date, that's really the aim of the exercise. So to produce this as a new tool for practitioners to use in their work. And I think that will help practitioners to apply and interpret the Geneva Conventions and to be, you know, to make their job easier and to be maybe better at their job because they will have all the relevant information at their fingertips. Today, that information is available for the first 3 conventions. So we've updated 3 out of 4 commentaries. And so it's available in print, online in the treaty database. And it's also available, I don't know if everyone knows this, on your smartphone in the IHL app, where you have the provisions of the conventions and also the commentaries. So I really hope that anyone working with the conventions today sees the new commentaries as a useful tool and as a starting place for their inquiry.
Perfect. I've used the IHL app and I find it very useful, personally speaking. So thank you for that initiative. As we officially end this meaningful conversation, I like to invite all 3 panelists to share their parting thoughts or comments on this very important topic. I want to start with Professor Lijnzaad and then Professor Murphy and then finally Dr. Henckaerts.
Well, thank you. Final thoughts. That's a challenge. I think it's been wonderful to have had the opportunity to look at the commentaries to the Geneva Conventions from the perspective of the law of treaties. Normally, I think when you talk about the Geneva Conventions, we get to the substance because that's why we think the conventions are important. So it has been good to take a step back and look at the conventions as treaties and how applicable law of treaties would help us understand the message of the conventions. So thank you very much for organizing this meeting.
So I will just conclude by saying that in international law, we do engage in treaty interpretation through the various means referred to in Articles 31 and 32. And we study what those means are, and we talk about them being important mechanisms for understanding the law. But we often forget how hard it is to do that. Maybe not so hard to look at the ordinary meaning of a treaty, but to try to really understand the context of a provision, to understand other instruments relevant in that context, to understand subsequent practice of the state's parties or relevant rules of international law that may also bind those parties and therefore be relevant to a treaty. It's not easy to do that analysis. It's not easy studying the negotiating history of these treaties. It's there, but it's not so common that people are pulling the volumes off the shelves and doing even more than that to try to figure out what the parties to the treaty meant in concluding the instrument. So in my view, something like the ICRC's commentaries really is an extraordinary resource because in many respects, it's doing that hard work for us. Even if you disagree with some aspect of what is there, some emphasis, some particular approach that's been taken, it's a remarkable project that I think all practitioners of international humanitarian law or law of war are actually rather grateful to the ICRC for doing what it's doing. Because I do think at the end of the day, it's helping us understand better the law as it was adopted, as it's being practiced by states. And in that respect, it's making the world a better place.
Yes, thank you. Yeah, I'm very happy to hear that, the recognition that it's not an easy task. And indeed, that generates two thoughts in my mind. One is that we have only finished 3 out of 4 Geneva Conventions, and we had hoped to already be further ahead. But actually, as we can see, we underestimated the time needed, and the work involved, because this update hasn't been done for the past 60 years. So, and a lot of time has evolved and a lot of developments have taken place. So that also means that it has been more work, and that if you want to follow the methodology of the Vienna Convention, it is time consuming basically to go through all the steps because we look at all the elements. As an aside on this, we tend to see this sort of, yes, it has been mentioned by Professor Murphy, it is one method of interpretation, but it pulls together various elements. So we have to look at all the elements, and that is time consuming. In addition, the process of review with the peer reviewers, making sure that we reflect all diverging views and so on, is quite time consuming. So certainly this should have been done much earlier. That's the second thought I wanted to make. So it's taking a lot of time. It should have been done earlier. We shouldn't have, waited 60 years to update the PK commentaries, but that is simply because it is so resource intensive that the ICRC, it took a bold decision basically from the ICRC to say, well, let's finally now update these old commentaries, because indeed we're in the 21st century. Many developments have taken place. These are the universally ratified treaties of IHL, and we as ICRC are the guardian of IHL, and we have a role to work for the understanding and dissemination of this body of law. So we owe it actually to all states parties also to undertake this task and to invest time and money in this. And so, yes, it's taking time and it's taking money, but I do hear and I do believe that it's really worth it. Thank you.
All right, perfect. So on that optimistic note, we'll end the podcast. Thank you so much, Dr. Henckaerts, Dr. Murphy, and Dr. Lijnzaad for being on the podcast. It was an absolute pleasure hosting all three of you. I hope you enjoyed this episode, and I'll see you in the next one. Thank you.